consultant in higher education, and for 14 years before that, I was the Director of Legal Resources at the National Association of College and University Attorneys. I want to welcome you in the room to this session, and also everyone watching this session by web stream. This is Current Legal Trends, Litigation, and Legislation. Also, I think has a subtopic called Legal Curveballs on the Horizon. I'm not going to repeat all of President Sullivan's great introduction of Peter. Peter, I just want to say there's a tour de force, as I told you. Great presentation. Give Peter another round of applause for that presentation just now. I was impressed, though, Peter, to learn that you are now interim director of Title IX compliance. Congratulations.
Condolences. It's running about 80-20, Carl. Yeah.
Right. But I do always appreciate the optimism and enthusiasm that Peter brings to his presentation. It's often said that one role of a lawyer is to be a professional pessimist, and that's certainly one side of my personality. We get paid to think about what could go wrong and maybe think about what might prevent it, where everyone else is saying nothing's going to go wrong. But Peter, your optimism is certainly the other side of that coin, so thank you for that as well. Seated next to Peter is Stephen Healy. He's the managing partner and co-founder of Margolis Healy Consulting. He's also, correct me if I'm wrong, you are also the co-director of the National Center for Campus Public Safety?
Chairperson for the Advisory Committee.
Chairperson for the Advisory Committee. And he was previously Director of Public Safety at Princeton University. And then at the far end of the table, the far left, is Adam Jussel. Adam is the Associate Dean of Students, Director of Student Conduct at Washington State University. We hope to have time for questions. There are question cards on the tables, or if you just want to raise your hand, someone will be around with a microphone. And those of you watching by web stream can submit your questions online as well. And with that, I will turn it over to Peter.
Oh, thanks, Carl. I believe the way we had this structured is we were going to talk a couple major points and then hopefully get a lot of audience interaction with the panel and with us, and we'll see if we can stimulate that. I had a couple of major areas of focus, which I actually did hit on very briefly this morning, and perhaps we can go into a little more depth with those here if you're interested. I see three areas of particular interest and focus of legal issues coming forward, and one which the President did a marvelous job of illustrating as well is First Amendment and constitutional issues. I am convinced that the next 2 or 3 years is going to be groundbreaking period in litigation over constitutional issues, particularly First Amendment challenges that relate to or connected with higher education. This year alone, we had several cases that I think were very, very significant. One which I'm watching like a hawk is the Alanis case, which is the Tone Dougie case. I don't know if you're familiar with this, but this was an individual who perpetrated threats on the internet, verbal threats against someone, and was prosecuted for that, and it went to the Supreme Court, testing the true threat standard under the cross-burning case from Another Generation, Virginia and Black. And the Supreme Court came back and basically said that in order to prosecute someone criminally, there has to be some mens rea, some bad state of mind. They weren't really willing to tell us exactly what that is at this point. But what that litigation is going to do is help define for college campuses what we can punish and what we can't in terms of speech on the internet and the kinds of threatening language that goes forward. I know we all struggle with that. As a Title IX coordinator, I went through many situations that dealt with basically some form of exactly what took place in the Alanis case. And so we're waiting to hear more from the courts, and interestingly, the Supreme Court decided to take a little bit of a breath on the issue. They want to let it evolve a little bit through litigation before they commit to a final standard, but I would be watching that one very, very closely. The other thing, and I think the President hit on this, but I can't emphasize it enough, is there has been a spate of activity, not in higher education particularly, where individuals want to censor content of speech, and they punish it or otherwise eliminate it. One is the Reed case that came out of Arizona. There were rules about speech on placards, and they said, well, you can have political speech but no religious content. And the Supreme Court took the case, and I think Justice Kagan said the standard was sort of laughably unconstitutional. But in the process, the court articulated something very significant, they reminded us that content-based censorship has to meet strict scrutiny under the Constitution, which is a test that's very hard to meet. And it sent kind of a shudder throughout many different industries, thinking the regulations that we've taken for granted for so long may not actually be as constitutional as we thought they were. I can be more practical and say that for the folks at FIRE, this kind of language and rhetoric from the Supreme Court is going to be a platform for probably a lot of interaction with our field about the standards that we've been using for some time. I do not think the Supreme Court is unaware of what took place in Oklahoma, and I would imagine that some putting up what occurred at Oklahoma with SAE against some of the decisions the Supreme Court has come down with on hate speech makes me wonder if we're in for some kind of a correction, even in a higher education case of some kind. So I see big changes there. I am absolutely convinced that we're going to get due process cases at high level, maybe all the way to the Supreme Court soon. I think it's inevitable now that a due process showdown is going to occur, probably at a Supreme Court level, probably sooner rather than later, maybe 2 to 5 years perhaps, or less. And what's really intriguing, and I made reference to this quickly this morning, but a little more particularly now, is the same-sex marriage case raises rhetoric about substantive due process, a special doctrine of due process that many had thought had sort of gone into desuetude. They've kind of resurrected it, and I don't know what they're going to do with it, but if they are actually intending to stand on some of that rhetoric, I think we may see some pretty profound cases coming from the Supreme Court, possibly correcting much of what's occurring in the compliance university that we're dealing with today. So I tell the people I work with, watch for big left and right turns. I think we're about to have some corrective moments coming from foundational law of the country. Not to belabor this, but I also think that academic freedom and administrative autonomy may also rise on the court. I've noticed that Justice Sotomayor has made a point of articulating academic freedom principles in cases, and it makes me think that there's a segment of the court that's very interested in resurrecting traditional doctrines of academic freedom and administrative autonomy. So I wouldn't be surprised to see that come forward. Keep in mind that Justice Kagan was dean at Harvard Law School, so you actually have a sitting administrator on the Supreme Court. And although the other justices have taught in colleges and law schools, she was actually dean of the law school, so she had to deal with a lot of stuff that we do. And I'll be really interesting when her voice rises up. She's been very cautious so far in the court, but I get this feeling that she's a sleeping tiger, that when she awakens, we're in for a real interesting opportunity to hear rhetoric from the Supreme Court. The other area that I see a lot of development coming, and I'll sketch it, maybe we'll come back, is instructional design. I mentioned it quickly this morning, but I think the next regulatory frontier is the law of instructional design and delivery. You see it at the cutting edge of this was the edX agreement that the government reached with Harvard with its MOOC, essentially. But I think you're going to see more of that rising in the classroom. It's coming up with things such as trigger terms for use in the classroom, how syllabi are constructed, disability law, compliance and syllabus, website design. Many different textures, I think, are occurring here. Even the comfort and service animal issue. So far, the Cirque du Soleil rules that we're dealing with that bring a lot of animals into our culture have largely been focused on residence hall accommodations. But I think what we're going to be seeing is classroom accommodations associated with this as well. Those issues are coming, and so here come the miniature horses and skunks and all the other creatures. I know this sounds really weird, and to put this on tape, you're all going to think I'm completely losing my mind, but I really do think we're going to have to give some serious thought about how higher education reintegrates animals into human higher learning. It was a big part of human higher learning for millennia, and we've taken the animals out of the learning process, but I think we're having to reintegrate them into our learning in a way that seems a little startling to many of us now, but I think it's actually going to become fairly ubiquitous going forward. And again, it sounds a little odd, but it's just one of the features of what I think is changing on instructional design. And then my third point is on governance and white-collar crime. Again, something I glanced at earlier, but I think we could spend more time if you're interested. Certainly, we're watching the Spanier-Curley trial to see what comes of that at Penn State. But I think there are deeper issues of how governance structures are treated under the law, what kind of accountability mechanisms are out there. We've seen a couple of articles recently about executive compensation in higher education, which is kind of a cutting-edge dialogue about who's in charge and what kind of skill sets do they have. And, you know, not to echo something that you hear in the national dialogue, but it is intriguing that the leadership structure of our institutions largely reflects the 1% of American society that controls most of the wealth in the country and is not as widely representative of the classes of people who actually attend our institutions. So you tend not to see a lot of operationally trained people in high leadership positions. That's beginning to change, but it's still something that's noticeable, and I see some legal and policy fracturing issues that are likely to occur because of that. So just some thoughts down the road.
Okay, I think that signals me. So I'm Adam Jussel again. I'm the Director of Student Conduct at Washington State University. And I have to laugh. I was walking back down the hall and they said, well, someone said, I'm going to go to the session with Stephen, Peter, and that other guy. So I guess I'm that other guy. Like Peter, I'm going to hit on three topics. Oh, sorry. Thanks. That maybe as a practitioner, I see kind of being a forefront in legal, largely compliance-related issues. I think that's going to be a theme again, as Peter mentioned, throughout this this conference. The first, and it's kind of a dinosaur, is the Drug-Free Schools and Communities Act. Back in 2010, and between 2010 and 2012, the Office of Inspector General kind of hinted that more compliance reviews surrounding the DFSCA would be coming to college campuses. We've seen that come to fruition. There's been reviews on college campuses that have looped in, and Stephen will talk about this a little bit more, Clery and Drug-Free Schools Communities Act compliance. So what that hints to me is that when the DOE comes on college campuses, it's going to be a systematic review. And something that's on the horizon out there, and it was hinted in recent comments by OCR, is the connection between alcohol and drugs and violence on our campuses. Mm-hmm. Can really see that the DOE making that connection. They've hinted at that. Actually, the federal Student Financial Aid Office in the Department of Education is what oversees Drug-Free Schools Communities Act. And they've acknowledged that campuses need to start acknowledging the connection between drugs, violence, drugs and alcohol and violence. I could easily see the connection being made towards Title IX compliance. And so when the DOE comes on campus, they cannot be systematically reviewing just an individual case or your Title IX compliance. They could also be looking at Clery, Title IX, and the Drug-Free Schools Communities Act. The other thing I want to talk about briefly, I guess my second topic, is mental health on the college campus. As a practitioner, I can't tell you how many phone calls I get a week from faculty administrators saying, the student wrote something in their essay and it's hinting at threatening someone and I don't know what to do. I want this student expelled and trespassed from my classroom. And I'm the director of student conduct, and I have to sit with that and go, okay. And it's a little bit of, I have to laugh, blood on your hands type of conversation where if something happens, I want someone to know, so that way it's on you now. And I have to echo Peter's sentiment, is less about the community and more about individual liability and thinking about the spirit of the law. And arguing with a faculty member as an administrator is always kind of fun. So, one thing there is that I could see the next big step in regulation federally and on the state level is there's no standard for mental health on college campuses, mental health services, excuse me. And what I mean by that is that at Washington State University, there could be this standard, and we could follow it, and we could have this many counselors available, and we could have this many people available in our health centers. But you drive down the road to another college campus at the University of Idaho, it can be completely different. Without a national standard, I could really see the federal government or the state government looking at that and saying, okay, we need to intervene, and now that becomes another big compliance issue. With that, as a practitioner, there's really not a lot of guidance on how to deal with these situations, very complex situations where students, the confluence of mental health, disability, threats, implicit threats, all of that. And there's not really a lot out there. We have the Spring Arbor case from 2010, which is kind of rote as of now. There's a decision from Western Michigan in 2013, which reiterated that threat to self wasn't a sanctionable offense in and of itself. So individual threat to self, in that case, it was a student was expressing suicidal ideations, and the DOE said you can't involuntarily withdraw that student. We have that, and then also there's an interesting, I guess, juxtaposition between that and our campus counselors, who have maybe ethical codes and other guidelines they need to abide by, and they're university employees. And all of a sudden they're in a conflict maybe where they have a student that's representing what they perceive as threats in those counseling sessions, and they have ethical guidelines to go a certain direction or maybe call the police or what have you, depending on what state you're in. And then they have the legal guidance that you can't suspend or expel students or involuntarily withdraw students that make threats to selves. I think that's an interesting place, and I can see that being a forefront of regulation moving forward. The third thing moving forward that I could see is these OCR consent decrees. OCR comes to campus. I'm blessed to be one of the many campuses on the list now to be undergoing an OCR investigation, which is just surreal in and of itself. It's the sword of Damocles a little bit. But these consent decrees, they have particularized individual parts of our process that, as Peter mentioned, have to go through regions and legislatures, and our students have public comment and all of these type of things. And there's sometimes a conflict between state law, the APA, due process, and the consent decree. So then the university is left with, well, which lawsuit do you really want to defend, basically? I think that's an interesting place to be, and fortunately I'll have our conversation with our lawyers when that happens. But I think that another element of that is kind of underlying is this institutional academic freedom. When does the institution get to decide its own rules and policies and governance? And even more than that, when do the students get to decide what those rules look like? Every time I look at our code and conduct, I think, gosh, how could a student understand and read this when they're 17, 18, 19, when I can barely understand it? And that's something that I think is interesting moving forward, is how do we structure the values in our codes and in the law in a way that our students are internalizing it.
Thank you, Adam. So when we first got together to talk about the legal issues that we wanted to cover, the resounding response from my two colleagues was, I don't want to touch Title IX and I don't want to touch Clear Air because if we go down that rabbit hole, we'll never get out. And so they left it to me to talk a little bit about Title IX and Clear Air. So I'm not going to talk about compliance issues per se. What I want to do is just capture a little bit about some of the themes that we're seeing as we work around the country with institutions, many of whom are in the room. So this issue, and Peter actually touched on it earlier, this issue of responsible employees. And I'm going to kind of evolve it a little bit to talk about responsible employees and campus security authorities, because what we know, if you look at the resolution agreements that are coming out of OCR, and remember that they're not coming out of OCR, right? They're coming out of different offices of OCR depending on where you are in the country. But there are many consistent themes, but one of the most consistent themes is this absolute, I guess, requirement for institutions to be engaged in some type of thoughtful process to identify and designate your responsible employees. So if you go back to Title IX and early guidance, back to 1997 or even 2001 guidance from OCR, they really focused on once a responsible employee knows or should know, right? So this idea of the response, now there was no conversation in the April 4th, 2011 DCL around responsible employees, and then they came back to it again in the Q&A. But it is in every resolution agreement that I've looked at, and most recently the agreement with UVA, the agreement with my former institution, Princeton, and a few others, all talk about this absolute imperative to identify your responsible employees. And so typically when we're working with institutions, we ask, okay, what have you done about identifying your responsible employees? And, you know, we really do get a hodgepodge, a mismatch of what institutions have done. And literally, as Adam mentioned, I could be at one institution, in one city and go a mile or 2 miles away and say, okay, what have you done? And they're part of the same system and have completely different answers. But the problem is that if you are fortunate enough to have the badge of honor to be one of the 155, I think this week, maybe 157 institutions that are currently under review, this will be something that you will be held accountable for. If you think about the rule of law and the compliance the OCR will hold you accountable for that. But I just don't see kind of a consistent approach across the community with respect to really rolling up your sleeves and identifying your responsible employees to figure out, so OCR doesn't say, although they give examples of professors and, they say teachers and other groups, they don't really say who should and who shouldn't be, other than the fact that it is someone who you should, that a student would think has the authority to take action in a sexual harassment or sexual violence case, right? So, I mean, that's pretty much the guidance. But the question then is, what have you done to try to identify those folks? And once you've identified them, what type of training? That's the other consistent theme with respect to responsible employees in the resolution agreements, is that you have to train them. And again, I see kind of a wide spectrum of what institutions are doing, both for identifying their responsible employees and then making sure that they know that you consider them a responsible employee, and then finally empowering them with the information that they need to make the decisions that you are requiring them to make as a responsible employees. So there's kind of like, there are two ends of the spectrum. Some institutions have just said, you know what, I'm just gonna flip the coin and hope that we don't become one of the 155 or the maybe 5,500 at some point institutions that are under review. And then the other end of the spectrum, institutions have said, I'm just gonna make everybody a responsible employee, right? And so I see a lot of heads nodding. And so a lot of folks have done, have done that. Now, I think the challenge with saying everybody's a responsible employee is then how do you ensure that they have the information that they need to have, right? How do you train them? Because that's what OCR says, that if you need to, once you designated those REs, those responsible employees, then you need to make sure you train. So how do you train every single person at the institution to ensure that that includes the custodian who has English as a second language and works deep midnights on your campus? How do you make sure that if you've said that this person is a responsible employee, how do you make sure that they have the information? So that, again, there's this wide spectrum of what institutions are doing, and I don't feel confident that we have really embraced the imperative to move forward with this requirement. I don't know. I'll do a very unscientific poll. How many of you all feel really comfortable that you have your hands wrapped around who your responsible employees are and that you've trained them? A show of hands. Oh, okay. All right. Okay. So, how many of y'all feel that you have a good handle around identifying your responsible employees? Okay. And notifying your responsible employees, telling them that guess what, you're a responsible employee, whatever that means. All right. And how about training them? So yeah, so the hands, like if you saw, they were kind of dwindled as we went through it. And I do think that this is fundamental to your Title IX responsibilities, right? So if you say, yeah, we've done a great job, and I know who my responsible employees are, But then if I go and talk to one of those individuals, do they know? And then more importantly, do they know what responsibility? And this is especially important when you're talking with faculty members, right? Because faculty tend to have this expectation that they can be a confidant, that they can have, I hate to say this, confidential conversations with their students or private conversations, and that they're not going to share information. And if you've deemed those individuals as responsible employees, then that's not possible. And so, you know, that's one of the challenges related back to really fundamentally getting your hands wrapped around what your responsibilities are under Title IX. Since the requirement is when a responsible employee knows or should know, then you have to take action if you don't know who those folks are. And then, so the corollary with the Clery Act is the same, campus security authorities. Now, this is something that's been around for a lot longer time, or at least we should have a better understanding, since the concept of a campus security authority has been around at least in a more pragmatic sense for a lot longer than the conversation about responsible employees. So when we do training, I always ask this question, you know, of the trainees. So how many CSAs, campus security authorities, do you have at your institution? And the numbers vary from 1, which can't possibly be true, all the way up to 4,000, which, depending on the size of your institution, probably is more likely, right? So again, your Clery Act, your fundamental Clery Act responsibilities are one of the major components about disclosing crimes that are reported, really rest with your designation, your identification, notification and certification training of your campus security authorities. And very rarely do I get kind of a positive response that makes me feel comfortable that we've really done what we need to do. I mean, every single program review report from the Department of Education that I read always cites failure to report crime statistics as required by the law. And generally, those issues relate back to gathering information from CSAs, from your campus security authorities, as opposed to the police or the security department appropriately classifying classifying their crime statistics. So this issue of CSAs is probably just as important as REs, responsible employees, and it becomes more important when we start talking about the next issue, which for me is Clery Act crime data, right? As I mentioned, every single program review report that I've read, there are not a lot of them out there from 2015, so I wish I could give you kind of current data, but the Clery Act crime data is a hot mess, right? We are failing significantly with respect to that, and that is, right, if you go back, and Allison Kiss is here, she's from the Clery Center, she'll tell you that, you know, the original, the Clery family, Howard and Connie, really thought about a trifold brochure that talked about some policies and that disclosed crime stats. Right now we have if you have a really, really good ASR, it's probably 60 plus pages, definitely the trifold. But the fundamental part of that is the crime stats. And how many of us really feel comfortable that you have your hands wrapped around the crime stats? I will tell you, I'm on a campus pretty much every week of my life. I have yet to find an institution that really does a solid job of gathering their crime stats. So when you look at when your ASRs, your annual security reports came out a couple of weeks ago, right? And everybody had to have, there was articles in the student newspaper, crime is up, crime is down, and those numbers mean absolutely nothing because we don't have a good handle. And given the focus on these issues nationally, and the focus both on sexual and gender violence, the renewed emphasis with OCR and the guidance and the White House Task Force, the Clery folks are also part of that, right? And so what I typically say is if you have a, if you have a Title IX problem at your campus, you probably have a Clery problem. It's just, I've never been in an institution that has a really, really great Title IX sexual and gender violence program and a poor Clery program. They go hand in hand. And a lot of it revolves around these crime stats. And I'm telling you, unless you're meeting on a monthly basis to talk about and reconcile your crime stats from all the different offices, I mean, think about it. You got your campus public safety folks, you have your Title IX coordinator, right? You have your student conduct folks, you may have HR, and you may have other disciplinary systems that are, or disciplinary processes somewhere else in the institution that may actually be holding on to crime stats that aren't being provided to you. ROTC, right? They actually have a disciplinary system, right? So it's possible. Athletics, they may have a system where they are sanctioning athletes. Hopefully, it's in addition to what the institution is doing, but I'm telling you, I've been in lots of places where they have their own thing. Student organizations, fraternities and sororities may have their own thing where they're holding students accountable. And so you may have crime stats there. The point is you need to have some mechanism. And what my recommendation is that monthly, all of the key players are sitting at the table and reconciling the Clery Act crime data. So for police folks, for law enforcement folks, this is something we do every month anyway, right? Because if you report to the UCR, which is the FBI's Uniform Crime Report, you have to do this. You have to monthly submit statistics. For institutions that are still waiting to do this at the end of the year or in June or July when the ASR is due in October, I'm telling you, you've already lost the battle and there's no way in the world that you are accurately reporting your crime data. We've done data audits at a number of institutions, and I'm telling you, when I say it's a hot mess, and that is a very technical term, it is a hot mess. And we have to get our hands wrapped around it because, again, if OCR comes in, there's also a probability, or there's a chance that FSA, the Federal Student Aid folks who manage the Clery Compliance Division, will also come in. And that's the worst thing. You think having OCR on your campus is bad? If you have OCR and the Clery Compliance Division on your campus at the same time, it is quite the nightmare. So that's my second issue. And then the third is really something that I'm kind of railing on because there's no excuse for us not to do better. The Clery Act was amended back in 2013, right? The regs went into effect in October of 2014. So it's been around. The VAWA stuff has been around for a couple of years. It's 2015. We're at the end of 2015. So, we have had a couple of years now to get used to what the requirements in the VAWA regulations, although sometimes folks say, oh, no, well, the regs just went into effect a couple of months ago, and this ASR was the first ASR where we actually had to comply. That's actually not true, right? The department was very clear that they expected us to make a good faith effort even in last year's annual security report. But that's not my point. The written notice of rights and options is probably one of the most visible physical manifestations of your commitment to these issues. Right, so when I go to a campus, that's the first thing I look for. What's your written notice of rights and options? Is it articulated in a victim-centered, trauma-informed language, and does it thoroughly address all the issues that it should address? Aside from the issues that you need to address from a compliance standpoint, does it really give a reporting party, be that if that person is a victim or a survivor or just a third-party complainant, does it really give them a good sense for how in the world do I get help? Right, and I will tell you, most notices that I have seen come very short of actually meeting that goal. That they were kind of developed and kind of taken from a whole bunch of different documents thrown together in a piece of paper or several pages, and we just give that to students. It's not accessible, and I don't mean accessible in the ADA term, but accessible. Like it doesn't make it doesn't help me if I'm a survivor and I want help. It doesn't tell me how I'm supposed to get help, right? So again, it is one of the most visible manifestations. I've seen some that are unbelievable, and I will tell you, University of Michigan, if you're looking for a really, really good one, University of Michigan has a really good one. UC Davis has a really, really good one. And those are just ones that I've seen in the last couple of weeks, so they're on my mind. But if you're looking for good, and Emerson College also has a really good one. So if you're looking for examples, but you really need to go back to your campus and say, hey, where's our written notice? And if you get a lot of question marks, then that's probably an indication that you might have a problem. Right, especially if you're talking to the Title IX coordinator. If the Title IX coordinator says, I have no idea what you're talking about, then you might have a problem. So those are my three issues, all linked back to really the current environment and the landscape and the reality that I don't think anybody's ignoring these issues, but these are nuanced issues that we really need to pay attention to, because if you're under scrutiny, either from activists on your campus, activists not on your campus, or the feds. Those are going to be things that they're going to be looking at, and you really need to be paying attention and make sure you get a good handle on those issues.
Steve, if I could jump in,
Please.
One thing I noticed as a Title IX coordinator, which you really raised here, is I tried to look at the dashboard on my campus of all the data points that I needed to assess as a Title IX coordinator, and I realized that there's a poverty of metadata system analysis, that I can get a good handle on what's happening in my discipline system, but it's hard for me to put all of the data points together and see where the crossovers are. I couldn't even find a product, really, that would offer me a way to improve my ability to manage that data. I could find products in particular areas, but a true dashboard was beyond my ability to develop on my own or to purchase. And I know pretty much all the consultants in the field. Yeah. So I feel like I probably did hyper diligence on this and didn't find that. The other thing which you also raised, Steve, which I think is one of the great challenges of Compliance U, is that we actually have to do a cross-metric analysis now on any compliance activity that we engage in. So you're doing your notice of rights and obligations, and it's clery compliant, but it also has to be 504 Title II compliant. Right. So if it's not available in a format that's accessible to individuals with disabilities, it blows that. Right. And that's Adam's point, which I think is the other feature, is that when they come knocking, the new era of regulatory investigation, loosely speaking, is to look at all of the data points and all of the metrics for compliance. So that, for example, when they went to VMI on a Title IX issue, they looked at the tenure and promotion process, and that got looked at, and it was a big part of the resolution agreement, actually. So what you're seeing is you really need someone who has eyes on the field and has the tools to see all the eyes on the field. And I think what we're seeing in the build-out of Compliance U is that our attempt to come into compliance practices is still catching up with the way these metrics are being thrown at us and how they interrelate to each other.
I mean, and to Adam's point, with the DFSCA, and if you can't say DFSCA, DFSCA, right? Like, who has compliance for that? And how many? FSA has responsibility for compliance with DFSCA. They're not going to come to your campus solely to do a DFSCA assessment. But when they're doing the Clery assessment, they're going to look at that. And I will tell you, reports that will be coming out in the near future will highlight how important the Department of Education feels about the DFSCA. But in reality, in higher ed, and I'm not saying every institution, but we've kind of moved away a little bit from focusing on high-risk drinking. I mean, it's just a matter of capacity. It's still there. There's probably still an AOD office. There's probably somebody still doing prevention programming. But how many of you all can say, yeah, we are completely compliant with DFSCA, which requires an annual notice to every student and every employee about all of your programs called the DAP, the Drug and Alcohol Prevention Program, the DAP. How many of you all can say that, yeah, I know that every employee and student at my institution gets that annual notice, and that I have a mechanism to provide that notice to people who join the institution after the date of the annual notice. Like, how many of us can, because it fell off, right? When the Higher Ed Center was defunded by the Department of Education, right at the time that the Department of Education was focusing on issues around drugs, alcohol, and violence, the compliance arm for that, or the check for that, went away. And that was even only a spot check of, I think they had to do 5 or 10% a year or something like that. But that went away. And so it kind of fell off of our radar. But now, because of that IG report that Adam cited, it's back on the radar, and it's given to the Clery folks as part of their mandate to evaluate. And I will tell you, everybody does really, really bad at it.
The point I'd make is just more on on a practical level. The way that we professionalize Title IX coordinators, the next era of that is the director of compliance.
Yeah.
It's the person on your campus that oversees drug-free school alcohol programs, Title IX, ADA, Clery, the whole nine. And that's, I think, the next wave is there's going to be someone above the Title IX coordinator. And that person, like Peter mentioned, probably going to come with some sort of protection about retaliation and that type of thing.
Yeah.
Yeah, well, I mean, you think about, so UVA has now an associate, is he associate or assistant? What is Gabe? Associate Vice President for Clery Compliance. Now think about that. When you think about the Peters, or the different eras, and think about where we are today, right? And so the Clery Act's been around since 1990. Since as long as this conference, 20 plus years. We're going to be celebrating that next month at the Clery Center event in DC. So just think about that. When the Clery Act was first passed, that belongs to security. Or if you had a police department, that belongs to the police department, right? It was over there somewhere. No one ever really focused on it until the ASR was published, and it got like 2 or 3 days of press, and then everybody went about their merry way, right? There are still some institutions where the chief's administrative assistant is responsible for the Clery Act, right? That's not going to get it. It's too complex, right? And I think, thank you to the VAWA amendments, institutions are now starting to at least catch on to this idea that it's not just for campus public safety anymore. It's actually for the entire institution. But to have an institution that said, we think that this issue is so important that we're assigning an associate vice president for Clery compliance. Person's not in the police department. Person reports to the EVP or the EVP. So I mean, that's a major shift. It's taken us a long time, and those of us who kind of do the Clery stuff and the Title IX stuff have been saying for years, you need to stop thinking about this as a campus public safety law, because it's not, and the more you think about it as a campus public safety law, the deeper the hole is that you're digging for yourselves. But it's become, it's evolved. I actually have a question for you.
Uh-oh.
So given the shooting in Oregon a few weeks ago, and this focus on social media and how we know that that's the predominant way that our students communicate, social media, and that we also know that there's some pretty compelling evidence or research that suggests that folks who are going to engage in those types of targeted violence incidents post stuff on media. How does that bump up against this concept of free speech and freedom of speech? And so if someone posts something and I get alerted to it, as a campus safety official or as a student conduct, can I just go and, can I kick them out? What can I do to sanction that person?
Yeah, I mean, this is exactly what the Alanis litigation is really going to help illuminate, is how can you respond to true threats? When is something moved from speech, which is ugly and unsocial, to something which is prosecutable and punishable? And unfortunately, the Supreme Court takes its time to catch up to the digital world. I think we could take years to get the law that we need to get all of the clarity that we'd hope to have. Maybe even an entire generation might have to pass while this occurs. And it is absolutely a challenge, because our strong U.S. free speech standards run headlong against safety. And most of the rest of the country isn't, shall I say, burdened by the First Amendment. If you want to think of it that way, they don't have to manage it this way. But it really challenges us to work with that. And I will say also for the private schools in here, many of us promise things to our students that mimic or even exceed First Amendment rights, and so we are similarly situated, even if we're not technically equivalent under the First Amendment for public school compliance. I think this is the next generation of issues, and part of the trouble, I think, is that there are many people who say things on the internet that are inappropriate, scary, even violent, and they really don't represent a significant threat to anyone other than themselves. They're just losers. And you know, I mean, this guy Tone Dougie from the Alanis case, I mean, when you read it, I just, to me, he's just a strikeout king. This is a person who has really, you know, hopelessly unsocialized.
These are very technical terms.
Yeah, I mean, but
loser
well,
and
yeah,
strikeout
yeah,
king.
well, you know, having been a disciplined person, you see a lot of this is people that are just not fitting in and their behavior is just completely inappropriate. A handful of those people become extremely dangerous and violent. And having the skills to know the difference between the vast range of people who have bad judgment and poor socialization and just they're mean-spirited, as opposed to someone that actually presents serious physical risk to themselves or other, that's a huge change. And it's almost as if we're going to start running our own version of Homeland Security.
Well, and it's an evolution, right? Post Virginia Tech, right? You know, so handful of institutions were engaged in threat assessment. There were others that were kind of had a care team or some type of other thing. And now, I haven't been on a campus in years that doesn't have some type of threat assessment. But now, the conversation isn't just if you see something or hear something. It's now if you read something, right? So the platform before, you know, in the immediate post-Virginia Tech era, it was about, well, if your roommate's kind of acting out, or if you hear them or see, or if they say something, now it's, well, they're probably not going to say anything, but they will say something, but it's going to be in social media. And so how do you pay attention to that? And if you see something, if you hear something, if you read something, then you have to do something. And then what is it that we're supposed to do?
Exactly.
Right.
And then are we going to be responsible to go looking for trouble as opposed to wait for it to come to us? Because that's the other thing a lot of schools are challenged with is should I make a proactive effort to get into Instagram, Snapchat, all these things and see what's happening out there? And then add another dimension to this is the people who are really some of the most dangerous people have become very technically proficient at hacking and identity hiding so that it takes special skills to even know who you're dealing with and how to track those folks down. So I think the digital universe is a huge challenge and raises constitutional and practical issues.
I think a challenge and an opportunity as well. Bulk of the conversations that we have in our kind of disciplinary processes where students are using social media in inappropriate manners, and I'll just broadly construe that, it represents an opportunity for us to educate them about the inappropriateness of using social media for inappropriate stuff, and how that lasts for a lifetime, and how that impacts your future, and how employers are going to look at that. You know, most of the cases, quote unquote, that we deal with that involve that type of behavior don't rise to the level of, well, this is an extreme concerning student that is going to come on campus and do something harmful. It's more, Dad, you just said something really, and this is another technical dumb on Facebook about your roommate, and that's really inappropriate. And let's talk about discourse and how to vet that and conflict management. So I think there's an educational opportunity there that we maybe sometimes miss the point of the kind of ongoing threat to our campuses.
Yeah.
So even if you approach it from a standpoint of, I'm just going to have a conversation because, you know, that was clearly inappropriate, the student could see that as an infringement on their freedom of speech.
Sure.
Right, and take that to the next level.
Yes, and so, and then you just have to hearken back to, you hope a court realizes the educational premise of what you're doing, and until the Supreme Court tells me I can't do it, I'm going to march forward and do what I can.
Sure.
So I think I don't have any other questions for you. I don't have any other questions for you, so I guess we should open it up for questions from the audience. And we have time, so we've caught up, so we have time. And
Sure.
Feel free to go back to some of the points that Peter raised in his opening session, and I'm going to do my best to try not to monopolize your time since I have you here and ask a whole bunch of questions. So
Yeah.
we should open it up.
If there are questions, well, there's a question right there.
Thank you. Jeff Allison from National Center for Campus Public Safety. Actually, a comment and a question. So you have a social media threat, and I heard the question, so what do you do about that? The FBI has 56 field offices spread all over America. Each one of those field offices has at least one person who's been trained to analyze communicated threats and can fairly rapidly give you some feedback on whether that threat's probably bona fide or not, and whether you need to take action on it. So that resource is out there for you. The technical title of that person is the National Center for the Analysis of Violent Crime Coordinator. The simple one is Communicated Threat Specialist. So they're there for you. A question, all three, but I think especially Peter, you're talking about the Supreme Court eventually catching up with our progress on social media.
Yeah.
Something more immediate. Back to the FBI. The FBI has a civil rights unit. Every year, the FBI Civil Rights Unit does numerous investigations of hate crimes on college campuses. Some of those hate crimes are primarily based on communicated threats. So if the Supreme Court's going to get more absolutist about the First Amendment, Peter, I guess primarily, how is that going to impact our civil rights investigations? How do we deconflict?
Yeah, I'm a little worried, actually. I mean, the prosecutor hat that I have from a past, you know, because I did work in a prosecutor's office for a while, not as a prosecutor, but as, you know, just assisting. There's been some really interesting rhetoric from the Supreme Court, including Justice Kagan saying that she's concerned that there's been an over-criminalization of behavior. Some of the First Amendment cases, which have unspeakable fact patterns, what you see is as the prosecutors are attempting to prosecute what looked to them like a crime based on similar criminal behavior, the Supreme Court's trimmed back their ability to prosecute that. Certain cruelty to animal crimes, for example, are now essentially unprosecutable because of recent Supreme Court decisions, which means that relying on the punishment side of law to help fix our hate issues is not necessarily going to be functional for us. We may not be able to turn to Homeland Security, FBI, or even our own discipline systems to be the first point of response. We're going to have to think about different ways to intervene with hate, mean-spiritedness, et cetera. And, you know, I'll just say it, but the Supreme Court has protected the U.S. constitutional right to be really kind of a mean, ugly person. That you can be that individual, and it's perfectly constitutional to do it. In situations that even startled me, and I tend to have a fairly broad view of the First Amendment. So Adam's point, I think, is particularly well taken, that we're going to have to think about educational interventions. I think more about community efficacy, and I think like what Southern Poverty Law Center does is it's more than just suing the hate groups and using legal tools, but it's trying to build communities of efficacy that themselves repel behavior that's marginal like that. And then I'll say something else as well, is that, you know, with a lot of the folks that really are dangerous and the situations that are very dangerous, when you put the pieces together, everybody could see the train heading down the tracks, but no one wants to take leadership to try to derail it or help it go in a different direction. I work a lot with the VTV families, the Virginia Tech families, and Joe Samaha, who lost his daughter that day, sometimes speaks of the shooter as one of the victims of the day, which I think is a remarkable moment of contrition, but he feels as if that's someone who was also lost that day because of what we might have done. And I don't know how he gets to that place. I don't know, I could personally do it, but he's an extraordinary human. And it really models this idea that if someone is lost in our community, we have an opportunity to help them be found. That, you know, not again to wax too reminiscent here, but you know, I do sort of believe in the spirit of Ohana. When people are lost, they're part of the family, and we don't want to leave them behind. And I think we do leave a lot of people behind. They're in their rooms, they're isolated, they're suffering, and nobody takes the leadership to say, how do I get to that person and help them out? We're living in a culture now where it's more acceptable to come forward and say, I've been depressed, I've been suicidal, I was raped, I was abused, I was bullied, you know, Demi Lovato's and others of the world. That helps to bring that forward and to create a community of care and compassion that fights that kind of evil. But I think there's a serious challenge because I think the law is making it harder to combat hate with law.
So I just wanted to, I'm sorry, I just wanted to kind of dovetail on the point that you made about a community response. Another checkpoint for you to think about the health of your campus. Do you have a bias incident response kind of system? So when something happens that may not necessarily rise to the level of being a hate crime, but it's something that's really concerning. What are your protocols or what are your procedures for responding institutionally with a unified message around what the ethos of our community are and what's acceptable and what, how we respond to and I think that kind of speaks to the community response. And now we've seen around the country institutions really getting their hands wrapped around that and doing a really, really, really good job. Wake Forest has a really strong bias incident response team and a system for responding. So I just want to give them a shout out. I'm sorry.
Yeah, that's okay. Dovetail off your dovetail. I think the community response, there's also a public health aspect of all of this, where we're educating our students not only about these behaviors and how using our discipline systems about why they're appropriate or inappropriate, but we're also educating students of how to be effective bystanders when they see something happening. I think providing those type of tools in advance and being proactive is part of our compliance driven aspect of this work, because that teaching and that education will enable students to have those conversations without ever floating up to my level or to the Title IX coordinator or to anywhere like that. It's just a lot of those conversations happening, we just don't even know it.
Mm-hmm. Yeah, so it's like we're straddled between the bystander era and the in loco parentis. So but we actually do want our students to take responsibility for their own stuff, yeah, right, and intervene and act when we see something. Sorry.
I have actually some questions from the audience, and this is a good one because it points to another set of personnel on campus, and it's for Adam. How do we balance responsible employees, mandatory reporters, with advocates and support people? Obviously, you need to be identifying both so the student knows which one is in which role, and who's confidential and who's not. And the question goes on to say that counseling centers are understaffed, and sometimes there's a stigma with going to counseling. So do you have any thoughts about that?
Yeah, to the first point, use your community resources. We've identified an advocacy group in the community that we use as that kind of advocacy arm for the university, so we don't get into a situation where we're trying to figure out role identity between us as the neutral fact finder and the investigator and the decision maker and the advocates. And what we've done is, after we identified that group, we've just trained them about our processes, about our procedures, about when and where they can intervene. We allow them to come along throughout the process. They're great after a couple years of working with them, because they can actually help go into courts if that's an option that a student wants to consider, to get no contact orders, anti-harassment orders. So it actually really bridges pretty nicely. We can sit down and talk to a student about resources. I can say, now understand, we're one response to what has happened here. There's many other responses. Let's talk about all of those and give students all of the options. And really, in that circumstance, trying to provide the power back to a victim that has been victimized.
Yeah, I just want to say something about the advocacy, and this is my opportunity to give a shout out to the University of California system. They've mandated an advocate, on a minimum of one advocate on every single campus in the system. And since that's now my home state, I want to give the UC system a shout out on that. And I know not everyone has the resources to do this, and when you don't, you want to leverage community resources. But I will tell you, in the next 5 years, every campus in this room will have an advocate on their campus. It's almost unimaginable that as we become smarter about victim-centered, trauma-informed approach, that we don't have our own advocate on campus. And again, the off-campus advocate can be a great resource, but it does take some some orientation to make sure that that person understands. And there has traditionally been some friction between the campus and off-campus advocacy, and you really need to sit down and uncover that tension and get to a place where you say, okay, we need to work together. But the only way that you can do that is acknowledge that there has been, because I will tell you, I talk to advocates, off-campus advocates all the time, and they will tell you the campus is hiding rape. They're hiding it, and they won't work. And, you know, yeah, they call us once a year, and we go up and we do the little dog and pony show, but then that's it. And their students are coming to us because they are afraid of what will happen to them if they report on campus. So you need to bridge that gap, and it sounds like you all did that at Washington State, and you're going to have to pony up the cash to have an advocacy center on your own campus. I think we owe that to our students to really address these issues. Having an advocate involved from the beginning of a report all the way through to the final adjudication, it is definitely an evolving best practice that I hope that you all consider moving forward.
I couldn't echo this any more strongly. I think we were headed headlong into a major rise of advocacy culture on our campuses. I think we need to be prepared for this on many dimensions, not just Title IX and safety issues. And one thing to keep in mind is that we could model our advocacy relationships on legal advocacy models, but I think the kind of advocacy that we're going to need to develop in higher education actually takes a very different path than how lawyers might advocate in court. I see it because I see the rise of lawyers being permitted to participate in Title IX proceedings around the country. This is a growing trend, but that's just the cutting edge of retraining advocates to a new kind of forum in which to be an advocate. I see this very much on the rise in our field, and I think by the time we come back 25 years from now, embedded advocacy will be a big part of our culture in a way that it probably has never been.
I hope I'm able to come back.
Me too. I hope we're here for it. We'll keep our fingers crossed. And the other thing, just to connect to some thoughts that Adam had too, and to some extent answer the question as it was posed, is I think we're entering a badging culture on campus. And I don't know that we're conceptualizing it that way, but once we've walked into the world with so many people being REs or advocates or CSAs, you have to know what your badge is, you have to know what it means, you have to understand the responsibility that goes with it. And I think we have an obligation, or at least an opportunity, to help our students and staff and faculty understand where the traps are with the badges, so that they don't walk in and have the wrong conversation with a person that they don't intend to.
Right.
So I go to an advocate thinking the advocate's going to tell somebody that I was sexually assaulted when they might not. And or vice versa, go to a responsible employee thinking I can have confidentiality when I can't. And when I was Title IX coordinator, I worked a lot on what I call traps, which I think are associated with the badging culture, because for every badging system, there's a trap. Someone could be lured to have a conversation that's one they wish they didn't have after they'd had it. And I think that's a big part of what we're building out now.
Well, talking about badging, I was at a campus a couple of weeks ago, and in the student affairs office, there's actually a sign on the that's the first person you see when you come in the office. There's a sign. She had a sign on her desk that said, you know, I am a responsible employee and I'm required to report issues related to sexual and gender violence. If you would like support or you'd like to talk to a confidential resource, I am more than happy to ensure that I can refer you to that individual. So it's a sign right on the desk. I don't know how I felt about that, but it's the badging. And we've been holding off on your question now for way too long.
Great. I'm Kathleen Boone from Damon College, and I want to pick up on two phrases that Peter was using in the plenary that we're still carrying forward, two themes, and bring them into some conflict, and that is respect for the rule of law.
Yep.
And this theme of how responsible we are and have increasingly become for safety and wellness. And I would like to get your opinions on the elephant, if you will, the pink elephant in the room, which is alcohol. And the extent to which, I mean, as we all know, the legal drinking age is 21. And I think probably just about all of us have thrown up our hands and said, well, at least we're going to give you some guidance on how to drink responsibly if you're going to drink and people don't, and so on. And you bring alcohol into the conversation, and the advocacy community becomes very concerned because there's a perception that victims are being blamed. I want to be very clear, I am not ever blaming a victim when I say, as we all know, that, I mean, the data show that the vast majority of campus sexual assaults involve alcohol use by one or both parties. So let me just be quiet and see what you all have to say about that.
Yeah, I mean, I have some pretty strong thoughts. You mind if I grab the ball
Yeah,
first?
no, go for it. Go for
Yeah, I feel like Kobe. It's like,
I want to stay out of it.
Yeah, well, one thought is that Safe and Drug-Free School was not written with Title IX of 2015 in mind. So clearly the government's going to have to give some thought of how to normalize the relations between the two. I also have seen that part of the reason there's been a diminution in emphasis on prevention work on alcohol and drug is exactly what you articulated, is that there's a concern of victim blaming will be associated with it. So how do you modernize prevention work into the Title IX universe where there's this reality that people are seeing this as a victim blaming maneuver in some circumstances? I think there are a couple of thoughts here that it might be helpful, and one that I've been doing in the trainings that I do around the country is I talk a lot about the weaponization of alcohol and how, particularly in sexual assault, certain perpetrators actually take an otherwise social product and weaponize it, the way that Jason Bourne can turn a pencil into a fatal object and can stab you with it, and et cetera. I mean, you can turn alcohol into a weapon, and they do that. And so I talk about how you can identify patterns of weaponization, desocialization of alcohol. And I think there are training opportunities there, because I think people that are not trained in this don't necessarily recognize when an ordinary object has been weaponized to be used against them in some way, and then how to defend themselves should that situation arise. The other thing I think that's helpful here as well is when you think about the rule of law, one of the big features of the rule of law is the respect that each individual has is to live their own life in a law-like way. And I'm not particularly opposed to altered states of consciousness. I mean, meditation is perfectly fine, the runner's high, and it's not like I haven't occasionally encountered a beverage that's fermented in my life, so I'm not going to walk down that path. But I do think that when one is involved in a culture where altered consciousness is ubiquitous, that changes how we make rules for ourselves and for the people around us and who we associate with. I mean, just to give you an example, I've noticed we went to Las Vegas this summer, and they've essentially decriminalized marijuana there, apparently, because you just get a contact high walking down Las Vegas Boulevard. It's gotten to the point where I don't really want to walk down Las Vegas Boulevard because there's so much marijuana smoke in the air. And I'm thinking,
You're not coming out to the Bay Area anytime soon?
Yeah, there you go. Okay. So what I'm realizing is that the legal change is creating other challenges for just making decisions in my own life about where I want to be, when I want to be there. I think we all have that responsibility, and it would be a huge mistake for any institution to try to arrogate the power of lawmaking over one's own life and to make those decisions for adults. That's where I think we left in loco parentis behind. We stopped trying to be the all-knowing parent. We make all the decisions for you. Today, we're realizing that students and staff and faculty also have to be responsible for making their own law just as much as we do ourselves. And so I think there's quite a challenge of balancing alcohol and drugs with all the issues that we have.
Yeah, I think that's, an area of compliance that we've lost sight of a little bit as we've dove into Title IX. But when you peel back kind of that whole issue in that situation, there's, like you said, alcohol and drugs behind that, and the socialization of alcohol and drugs. And so I think Peter's right, is that instead of using our disciplinary systems as just a reactive measure to those issues, is being proactive and providing training in advance for students about there are these rules, and if you break these rules, here are the consequences for alcohol and drug use, but also protecting students that are victims when alcohol or drugs are involved. So, for example, on our campus, we don't discipline students for alcohol and drug-related issues if there is a Title IX associated case investigation ongoing. our primary concern is the impact on the victim and the complainant and the respondent in that situation, not their use of alcohol or drugs.
See, we have a question in the audience. I want to ask this question really quick because it sort of goes back to the badging issue, and then we promise we will get to your question as well. And it goes, this is for Stephen, and it says, can you offer thoughts on mandating non-employees as CSAs or responsible employees and saying that they must report?
I'm experiencing deja vu. I was in a group of fraternity and sorority executives last week, almost the exact same time, having this exact same conversation. So, a campus security authority is well, it's not that technical. There's a definition, and it's in the handbook. So the regulations speak to it. When I say the handbook, I'm sorry, the handbook for campus safety and security reporting it has about 5 pages of additional information, compliance about, about what a CSA is. But the bottom line, a campus security authority is an official who is expected to take action on behalf of the institution in certain matters, right? The handbook also says that volunteers can be considered CSAs because if they're volunteering for the institution and there are some expectations. So volunteer coaches, I worked at Princeton. They have a lot of volunteer coaches. There's a sprint football team, and all the coaches are volunteers. But the sprint football team is a university entity, and the volunteers do so on behalf and have some expectations to the institution. This question becomes murkier if you are a volunteer and you're a volunteer advisor for your fraternity or sorority because you were a member of that and now you want to volunteer. You're not actually volunteering for the university, you're volunteering for a private entity, and the issue becomes much murkier. So volunteers can be CSAs, so non-employees can be CSAs. I think the bottom line is that you really need to sit down and look at all of the groups of people that you have on your campus. That's how we get from one is never the right answer about how many CSAs you have, and it's probably closer to the 4,000 number, right? And I'm not joking when I say that. You know, if you have an institution, if you have 10,000 students, you probably have, I'm guessing, around 3,000 full-time, FTE equivalent employees. So that's a community of about 13,000 people. You probably have at least 2,600 to 3,000 CSAs. And I know that's shocking to some people. I actually see people looking and saying he is absolutely insane and he's lost his mind. But I'm serious. I'm serious. It's usually about 20% of your community. And when you look at the functions and the expectations that the institution has for what these people will do in response to an incident, then that's how you get to that number of about 3,000 for a 13,000 person community. So yeah, non-employees can be CSAs. Absolutely, they can be CSAs. Absolutely. But I wouldn't necessarily say that a non-employee volunteer who's volunteering for a private entity that is somehow associated with the institution automatically becomes a CSA. So that was the conversation I was having with the fraternity and sorority executives about their volunteers who serve as advisors for their entities may or may not be CSAs, and it depends. And the institution still has the flexibility to say you're a CSA. If you want to volunteer as a leader or as an advisor for this organization, which we officially recognize, we're going to tell you you're a CSA. Then it's going to be up to the organization, in this case fraternities and sororities, to make a decision about whether they want to play or not.
Okay, question back there.
In talking how you guys were about the First Amendment and things going on there, we're starting to see a lot of anonymous things come forward? Like, we have a confessions page on Facebook that's student-run, student-moderated.
Nice.
Yik Yak, all of these
Yeah.
things. How is that going to shape what we're dealing with? And holy cow, where do we even start?
Yeah, 3 minutes to answer that question, sure. And we'll rewrite the U.S. Constitution right now, together as a group, and accomplish that in 3 minutes. It is interesting to me that this generation of communicators exists in a kind of First Amendment space that the framers really couldn't have imagined, because everybody can publish now instantaneously to millions of people, and then things are persistent in a way that human knowledge has never known before. We lost half of all of human learning in an afternoon when they burned the library at Alexandria. Today that's impossible. I could have it all on a hard drive and just reproduce it. And the other feature of communication today is the extraordinary ability to mask your tracks through anonymity. Now, all of these things have existed before: persistence, dissemination, publication, anonymity, but everything is in hyperdrive now. It's accelerated to an order of magnitude I think the framers wouldn't have understood.
And the world is flat.
Yes. And Columbus thought he discovered America. So it's like, hey, there you go. How do we manage that? How do you translate the First Amendment to this hyper world when there isn't any group of people that have ever lived in this world before quite the way this group has right now? I think it's a challenge. Now, I will say the law has been somewhat solicitous of our problems. So in Title IX, for example, anonymous complaints get treated differently than others. If you see a pattern, you move on it, but otherwise you don't have to engage in a whole lot. But I think what we're looking at in the future is that each and every one of these variables, the ability to publish, to disseminate to wide groups of people, to persist knowledge, and to be anonymous, will have to be discussed on our campuses thoroughly and work through as a community to develop how we want to manage those issues and what we think we're capable of, et cetera. It hints at something I said this morning. I don't think we're teaching the First Amendment. I think we're responding to problems that are raised in a culture that isn't always dealing with First Amendment issues. I'll give you a quick example. I know I'm taking too much time, but we worked with a campus that described itself to us as a community of nerds. And they were concerned that people weren't communicating with each other, so they created one chat room for everybody to come into. And as soon as I heard that, I put my hand down, because if all you build on the Wild West street is a saloon, people are going to be mistreating Miss Kitty, spitting on the floor, and beating up Festus, if you know Gunsmoke, this old reference, but if you get it. I mean, it's going to be the Wild West, and that's exactly what they got, and they were startled, and I thought, you are really smart people, but your poverty of imagination on building a First Amendment universe is startling, that you've got to create spaces that people want to go to. See, I think people get drawn to these anonymous spaces because they can't find any place else to go. And the hate comes out because they feel frustrated that no one's listening to them. Creating communities of affinity based on values that are actually enforced, bringing people into the fold as opposed to just pushing them to the margin and forcing them to force themselves in with a hood, is a bit of a problem. So I think there's an opportunity to build out the First Amendment on your campus, to create a more textured universe where anonymous behavior is just less appealing. I mean, why are people going on Yik Yak? Because they're bored. And so what does that really tell me is that our instructional design is lagging. If I can't keep my students' attention, if they'd rather be yicking themselves as opposed to listening, then I need to work on how I'm teaching them, because they're not really paying attention to the lesson. It's just boring. And a lot of hate is actually born from boredom. People just don't have anything else to do, so they start going down this dark path. So just a thought there.
Yeah, just real quickly, because we're on time, but I think, your students are tools in that conversation, right?
Yeah.
Sometimes you see that prevalence on Yik Yak or Facebook or Confessions or whatever it may be. We started looking at our students to say, well, how do you want us to handle these situations? And that conversation bore out a lot of exactly what Peter was describing. Was, well, the reason I posted this is because the person down the hall said X, Y, and Z, and I didn't really know how to manage that, so I put this up, and there's a lot of frustration and anger born in that, but then we use that as a tool to, hey, what could we do better as administrators to make sure you aren't bored, to make sure that conflict never happens. So we use it as a conversation more than anything else.
Great. Our time is up. So thank you very much. I appreciate, I'm honored to be able to be up here with these folks, and thank you for all of your great questions. Take care. See you around.
Very much.
Great job.
Good moderator. Yeah, we could be here all day.